Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is 7 deadly lien and release traps and how to beat them. So without further ado, I'd like to introduce the wonderful and fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today we're going to talk about 7 very specific deadly lien and release traps we see clients fall into. And I'll talk to you about how to solve and beat each one of them. So let's get started. So on your screen, you should have the GoToWebinar chat box. You can use it to control this webinar. We will answer all the questions at the end. Please do not include any names of companies or people in your question. So go ahead and submit your question as we go through the presentation, and Jesse will read them at the end and we'll answer every one of them. So let's talk about the agenda today. We're going to talk about some lien law basics. It's always a good idea to understand the basics. Understanding the basics will highlight where these traps exist. We're going to talk about 4 lien law traps. We're going to talk about 3 release traps, and we'll answer any questions you have. So let's get started. So let's talk about how to secure your lien and bond rights. So step number 1, within 45 days, no later than 45 days from your first work or delivery of materials, you need to serve a notice to owner on the owner and the contractor. This is if you are a subcontractor, a subcontractor, or a supplier to a sub or sub or the GC. So step 1 is you got to serve this notice to owner. This does not apply if you have a direct contract with the owner. So I may be a plumber, so I'm normally maybe a subcontractor, but when I'm hired directly by an owner, I don't need to send the notice to owner to have these lien rights. That being said, I recommend that everyone always send a notice to owner, because sometimes you may think you're not a sub and in fact you are, or there's issues with the owner. More importantly, it's a fantastic collection tool. Sending that notice to owner can be a pretty scary document. When it's received by the owner, they'll take you much more seriously. Just by sending notice to owners, you will probably increase the likelihood of getting paid. Step number 2, within 90 days of your last work, you need to record the lien. You can also record the lien while you are working. This is a very important fact that a lot of people don't understand. Sometimes they think that you have to be done with all your work in order to record your lien. That is not the case. If you want to exert pressure and not obviously wait till the end or walk off the job, you can record your lien while you're working. So that's a great collection tool as well. Now, if you have a claim on a payment bond, that is a job, for example, a public job that's bonded by the contractor, or a private job where the lender or the owner have required the contractor to issue a bond, you need to serve the statutory notice of non-payment within 90 days of your last work. So it's not a lien, it is a notice of non-payment. It's also a document that is signed and notarized, but it is not the lien form. It is a different document. So if a job has a payment bond on it, that's what you have to do, a notice of non-payment within 90 days of your last work. So step number 3, within 15 days of the date of recording of the lien, you have to serve a copy of it on all interested parties. Of all the rules we've talked about and we will talk about, this is the only rule where there is no hard and fast penalty by not doing it. So you are obligated to serve it within 15 days of recording, but if by some chance you don't, it doesn't automatically invalidate your lien. Again, you should still do it, and if you use the great folks at SunRay to handle your notices and your liens, they do this for you automatically. Step number 4, If you have a direct contract with the owner, again, irrespective of your scope, even if you're the plumber or a roofer, you need to send a contractor's final affidavit, a CFA, no later than 5 days before you file a lawsuit to foreclose on your lien. We typically recommend that you do the contractor's final affidavit when you record the lien. So if I'm a roofer and I'm doing work directly for an owner and I haven't been paid and I want to secure my lien rights, I'm going to prepare a lien and record it. And I would recommend at the same time that you do that, you prepare your contractor's final affidavit. The contractor's final affidavit is a sworn document that is prepared, and it says, this is my name, this is who the owner is, and I had a contract with the owner. Here's how much I'm owed, and here are the people that I still owe money to. That's what this contractor's final affidavit is. This document is prepared, signed, notarized, and sent via certified mail to the owner. It is not recorded. You don't have to record the CFA. But again, we recommend when you have a direct contract with the owner, you do it at the same time that you do the lien. And then the final step, step 5, is within 1 year of recording the lien, you need to file suit to foreclose on the lien. There's no such thing as re-recording the lien. So when the time comes, you got to file that lawsuit to foreclose on the lien. That's the only way to keep the lien alive. If you have a claim on a payment bond, you need to file your lawsuit within 1 year of your last work, which is slightly different than a lien claim. So just keep in mind that there's a slight difference in when you need to file that lawsuit. My advice is you shouldn't be waiting anywhere near a lien. You should be doing it within anywhere from 30 to 60 days of when you record the lien or serve your notice of non-payment. If you still haven't been paid, that's when you should think about hiring a lawyer to pursue your rights in court. Okay, with those basics out of the way, let's dive right into these 7 traps. So trap number 1, service of the notice to owner is the date it is received, not the date that it is sent. So said a little differently, the notice to owner must be received by the 45th day, not sent by the 45th day. So if you put the notice to owner in the mail, certified mail, on day 41, for example, from your date of first work, it may not get there by the 45th day. What if it gets stuck between the seat, in the postman's truck, and it doesn't get there until the 46th or 47th day? Unfortunately, you will not have lien rights. Now, counting the lien dates is very important. We've created this tool. It's called the CalcuLien. You can get it completely free if you go to calculien.com. You'll see a little video on how it works. Put in your information. We will send it to you completely free. It's a great calculator that will calculate the 45 days for first work and 90 days for your claim of lien or notice of non-payment. Again, calculien.com. So there is a way to overcome this, and that is if you send the notice to owner no later than the 40th day, 40th day, and have it confirmed as received by the post office, then no matter what, it's deemed served. So the good folks at SunRay, when you use them to do your notice, they take it to the post office. If you get them the notice early, they will bring it to the post office by the 40th day. They will get a manifest stamped with the information stamped by the post office. So even if the mail truck blows up and the notice to owner never gets there, if you have proof that you prepared the notice to owner and a copy of the manifest, which SunRay will give you, that is considered properly served. So you don't have to worry about getting there, it being delivered, as long as it's been served or brought to the post office by the 40th day. All right, so lien trap number 2, retainage must be liened within 90 days. I get this question a lot. There is no exception in the lien law to extend the time to record a lien if all you're owed is retainage. So if you are the foundation contractor, the underground contractor, and maybe you did all your work at the beginning and you're owed $50,000 of retainage, you need to record your lien no later than 90 days from your last work on the job, even if all the money that's owed is retainage. People will try to convince you that that is not the case. Oh no, you're owed just retainage. Don't worry, you have more time. That is not true. You need to record your lien no later than 90 days, even if the amount that's owed is just for retainage. Now, there is another rule for jobs that are bonded. Okay, so if the job has a payment bond issued by the contractor, then if you are owed just retainage, the time to serve the notice of non-payment doesn't apply, meaning you don't have to serve a notice of non-payment within 90 days of your last work if all that you are owed is retainage. Now, the unclear part of this rule is, what if you're owed $100,000 worth of retainage and $10 of base contract work? Our advice is, because the statute is a little unclear, because you're owed some amount for that's not retainage and some amounts that are, we advise our clients, you need to send a notice of non-payment for the entire amount, all of the retainage and all of the contractor approved change order work. So that, by the way, is the distinction for bonded jobs, why some people will tell you, no, you don't have to lien for retainage within 90 days. Again, remember, if you have a job that is not bonded and you have lien rights, you have to lien for all of your retainage within 90 days of your last work. Okay, lien trap number 3. If the notice of commencement is terminated, you only have 30 days to record your lien, not 90. Remember, we said that the regular rule, the standard rule, is you have 90 days from your last work. But if the notice of commencement is terminated, maybe there was a sale, maybe there's a new contractor, old contractor out, new contractor in, maybe the job is refinanced. That's typically where we see this happen most of the time. You must lien for all amounts owed through the period of the termination within 30 days of the notice of commencement being terminated. How do you know that the notice of commencement is being terminated? Typically one of two ways. One, because there's a refinance or a closing, everyone's talking about it. People are asking you for final releases so that they can close you out. Sometimes they're going to ask you for final releases without paying you. We're going to talk about that in a minute. Sometimes you'll get a copy via certified mail that the notice of commencement was terminated. Now, there is an exception. If you've already issued a final release, no one is going to send you a notice of the termination because they don't have to. So be careful. If you've issued a final lien release, then if you happen to go back on the job, no one is going to tell you that that notice of commencement was terminated. So let's talk about how to deal with this. Know that, and this is the pro tip, getting paid because the notice of commencement was terminated includes being paid for all unpaid retainage through the date of termination of the notice of commencement. Most owners and contractors are going to object. They're going to say, hey, yeah, we have a refinance. It's happening at the end of the month. We need a release from you, a final release. And I know you're owed $50,000 of retainage. We're not going to pay that to you now. You need to understand that the rule, the lien law rule, is that you have to be paid 100% of what's owed through the point of time of the termination of the notice of commencement. If you are not, then you only have 30 days to lien for it after the notice of commencement is terminated. So what is the worst case scenario? Someone convinces you, oh no, you don't need to be paid that $50,000 of retainage. You give them a final release, you get to the end of the job, there's a dispute and they don't want to pay you, you try to lien for that amount, and technically that amount is not lien. That $50,000 of retainage that existed prior to the termination of the notice of commencement, you do not have lien rights for that amount. Okay, so you have to be paid everything, including all of your unpaid retainage. I have arguments constantly with lawyers for owners and lawyers for contractors who try to convince me. And when I point them to the statute and ask them, okay, show me where it says that there's an exception for retainage for me being paid in full to have lien rights once you terminate. And of course, it doesn't exist, and they back down. Now, there is a compromise position, right? We don't want to go to war over this issue right now. And the compromise position is they pay you that $50,000 of retainage now at the time they terminate the notice of commencement, right? So you get paid it. So they paid you now 100%. And then in the next draw, you give them a credit back for the $50,000 that they gave you early, right? So that's a way to kind of, with paperwork and math, get the $50,000 over the notice of termination. Now, here's the pro tip as well. Second pro tip on this: once the termination of the notice of commencement happens, they're going to record a new notice of commencement. Once that happens, you need to serve a new notice to owner. If you don't serve a new notice to owner now that there's a new notice of commencement, you will not have lien rights for your future work. So keep that in mind. It's a very confusing time when a notice of commencement is terminated. So be aware of these differences in the rules. All right, last lien law trap number 4 here, before we get into the release traps. Your first work and your last work have nothing to do with the day that you send a bill or your invoices. The notice to owner deadline is not calculated from when you send your bill or when amounts are due. It is based on your actual first date of work or delivery of materials on the job site. The lien is not calculated from when you send an invoice or a payment application or when funds are due. It's when you do actual meaningful contract work or approved change order work for the or delivery of materials. So don't look at your records and say, okay, well, when do I need to record my lien? And you say, well, I sent my pay app on this date. That is not the trigger for when your lien rights start to run. It's when you last had meaningful work, whether that's labor or delivery of materials to the job site. So if you did last work on the 7th of the month and you didn't send your bill out till the 25th of the month, the date is that you need to calculate your lien rights is from the 7th, not from the end of the month. So I told you about the Calculene. We also have another tool. It's called the Lien-O-Matic. It's a handy desk tool. It will explain a lot of the lien law rules that we talked about in great detail. It's a very simple tool that you can use to get quick answers to your questions about the intricacies of the lien law. It also talks about bonded jobs, federal projects, state projects, and FDOT projects, where the rules are similar but not identical. And it's those little differences that really make a difference. You can get it for free at lienomatic.com. All right, let's talk about these release traps. Release trap number 1, email copies of signed releases are valid even if the original is never delivered. Some believe incorrectly that because they're holding this original release with their blue ink and their stamp, that what they've sent to somebody via email is unenforceable. That is not true. If you send someone an unconditional release and you never get the payment, you probably have given up your lien rights. So if I'm a supplier and I give the sub my release, it's not conditioned, and I'm holding the original and I send them the copy, and they take that copy and they give it to the contractor, and the contractor gives it to the owner, and the owner funds, and I never get that check. It never makes its way back to me. I have lost my lien rights because the owner reasonably relied on my release. So how do you solve this problem? You need to expressly condition your release on you getting the actual funds. So you can have language like, notwithstanding anything to the contrary, this waiver and release is conditioned upon and not effective until the undersigned receives paid funds of blank. So if you're expecting a $28,000 check, you can write this on the release, put in the $28,000 as the amount that you're expecting, and now this release is conditioned on you actually receiving the funds. Now, we have another tool. It's called the Make Me Conditional stamp. You can get it for free at makemeconditional.com. It has that language on it. So if you want to make any release condition, you just get the stamp, you stamp the release, you fill in the amount of the check that you're expecting, and you send it along. And now you've made that release conditional. Release trap number 2. Once you provide a final release, you need to send a new notice to owner to have lien rights in the future. So as an example, let's say you're a supplier to a subcontractor and someone asks you for a final release. You're not owing any more money. You issue that final release, and then you're asked to deliver more materials to the project. Because you issued a final release, in order to have lien rights, you need to serve a new notice to owner, and that notice to owner needs to be served within 45 days of the delivery of that last set of materials. If you don't serve this new notice to owner, you will not have lien rights on the new delivery of materials. So be very careful about when you send a final release, so that if you have future deliveries or future work, that you timely send a new notice to owner. Release trap number 3. The through date of the release controls over the payment amount. Let me explain what I mean. If you are expecting a $10,000 check that's going to pay you through July 31st, but they're only going to actually pay you $8,000, not the $10,000 that you are due for that month, you need to change the through date of the release to match the $8,000 that you're getting. So what do I mean? I mean, you need to say, okay, well, $10,000 gets me paid to the end of the month. $8,000 doesn't get me paid to the end of the month. It gets me paid maybe through July 23rd or July 17th or July 4th. You have to figure out which date applies to the amount of money that you're giving, such that the remaining portion of the month equals the amount of the money that you are not being paid. The through date, right? The date that this release is effective through is always going to control over the amount. So you need to make them match. So again, you have to change the date. You have to say, no, I'm not accepting that. You need to pay me my $10,000 for a release through the end of the month. Or you need to include some type of exception. So maybe $8,000 pays everything but one invoice, which is for $2,000. So you can say, fine, I'll release it through the end of the month, but this release excludes invoice 1234, which is the invoice for $2,000. We have a client now who received payments for bills. All of those bills or pay apps were short paid. They agreed to accept the short pays, but they signed releases through the end of the month each of those times. They've come to us now that they're owed, I think it's like $96,000 that they're owed for all of the miscellaneous short pays. Unfortunately, they signed releases through the end of each month that were unconditional for the amount they actually received, and we've had to give them the bad news that they don't have a great case, because every month they were signing releases for that amount of money. And their answer was, well, you know, I submitted a pay request for $80,000 and they only paid me $50,000. Yes, I signed a release through the end of the month that said I was getting $50,000, but what about the pay app that said I was owed $30,000? And then the answer is, well, you kind of gave up those rights because you agreed to take $50,000 to release you through the end of the month. So be very, very careful about that. And with that, we are done. Jesse, do we have any questions?
First of all, thank you so much, Alex. As always, you were incredible. We do have a question that came through. It says, for a notice of commencement that has expired and they create a new notice of commencement, so you still, and I believe this is the question, so you still need to get retainage paid and transferred to the new NOC?
No. So if a notice of commencement just expires because it had a duration, either 1 year, which is the standard, or it had a specific date, and now we are after that date, that is That is the expiration of a notice of commencement, which is different than the termination of a notice of commencement. So the rule that I explained to you applies to the affirmative act of the owner terminating the notice of commencement, which is a process of filing new documents. It does not apply to notice of commencements that just expire.
Okay, wonderful. Thank you. Another question that came through, it says, if I'm still working on a job but haven't been paid and I lien while I'm still working on the job, can I put my full contract amount or just the amount for the work already completed? But then how do I update the amount if it rises?
Okay, great question. All right, so here's what you do. So let's assume that you're working on a job and you're owed $100,000 and for the work you've done that has not been paid, plus you're owed another $50,000 for work left to do, and you're also owed $20,000 of retainage. My advice would be that well, let's break it into its component parts. You cannot lien for work you have not done. So your lien will never and should never include work and materials that haven't been done or materials that haven't been delivered, right? So in my example, that's 50,000. That doesn't appear in your lien, right? We'll talk about that in a minute. The $20,000 that I said is retainage, you should not put it in your lien. You should footnote that you're owed 20 grand. And when I say footnote, it's a footnote in the lien. So your lien amount is going to be for the 100,000. It's going to have a little footnote. And then at the bottom of the document, it's going to say, we are also owed 20,000 in retainage, which is not being claimed in this lien. And the reason why you don't want to lien for retainage when you decide to lien while you are working is because if it works, you want them to pay you. So they can pay you the 100 grand. If you lien for the 120, right? That's the amount due and the retainage. They're going to say, well, I'm not going to pay you the 20 because you're not due the 20. You're not done. And that's technically true. So when you have to release it, you're going to release 100 because that's all they've paid you. So now you have this $20,000 lien. So you haven't solved the problem because they're paying you to get rid of the lien, but you can't release that $20,000 lien, that $20,000 of retainage that you liened, because the moment you satisfy that 20,000, you cannot lien for it again because you're satisfying it. So the way you solve the problem is you lien for the 100 you're owed, you footnote the 20 that it's retainage that it will be due when you're done. They pay you the 100, you satisfy the lien for 100. And then the second part of your question is, okay, what do you do when you keep working and you need to lien? You just amend the lien. So let's say another 2 months go by and now you're done. Maybe they paid you some of the money, maybe they didn't. You're just going to amend the lien. So the document is called an amended claim of lien. You amend it to include all of the amounts that are due at the time that you amend the lien. And you can amend the lien up to 90 days from the date of last work, of your last work on the job.
All right, wonderful. There are several other questions that came through. The first one I want to address, it's a very simple question. It says, what is retainage? I figured that's a good one to start with.
So retainage is an amount of money that is typically identified in your contract. Usually it's 10%. And it's a holdback that the owner holds back from the contractor and the contractor holds back from the subs. As an amount of money to ensure that the work gets done. So it's like a little security deposit that's kept. It's typically common in commercial projects, much less common in residential, and does not exist in service work. But that's what retainage is.
Thank you. The next one says, the recent changes in lien laws never allow us to recover financing costs. At what stage in the process should these financing costs be recovered to ensure they are eligible for recovery?
So I'm going to disagree. The most recent change, which I think was 2 years ago, to the lien law specifically incorporated the right to be paid finance charges as part of your lien rights. So for example, if I'm a supplier and I sell plumbing supplies to a plumbing subcontractor and my credit app says I'm entitled to 18% interest, I can lien for and recover from the owner in my lien my 18% of finance charges. So it is specifically now an enumerated right in the lien law to be entitled to recover finance charges. The way we do it when we prepare liens is we just list the principal. So we say, and our client is owed $100,000, and we say plus interest, comma, legal fees, comma, and costs. We don't identify the amount in the lien. We just say that we're entitled to it. And then when it comes time to figure out how much we're owed because the other side wants to pay off the lien, that's when we do the calculation and say, okay, well, you owe us $100,000 and $11,000 in interest and $3,000 in legal fees.
Okay, perfect. Thank you so much. The next two look like they're going to be fairly quick little answers for us. If a notice of commencement is terminated and the contractor doesn't send a copy to the potential lieners, do we still only have 30 days to file a lien claim?
So that was a recent change as well in the lien law in the last, I think it was 2 sessions ago, and it makes it very clear that if you do not get notice of the termination, the 30 days does not start to run.
Perfect. Thank you so much for that. And then the next one, it says, as a contractor, how do I protect myself when paying subcontractors from subcontractors or material suppliers who subsequently send an NTO after I've already paid my sub, but still inside of the 45 days?
Yes, I'm trying to think of the best way to answer this question. So at the end of the job, you are supposed to give that contractor's final affidavit to the owner in order to induce final payment as the contractor. I said that at the beginning when we talked about the rules, you have 45 days from your first work to send that notice to owner. However, if you give the owner that contractor's final affidavit, that cuts off the time that anyone has to serve a notice to owner. So if I'm the fencing contractor and I show up 2 days before you ask for final payment because I install a fence in a day, and now I have 45 days to send my notice to owner, I actually only have, in my example, 2 days, because the moment you sent that contractor's final affidavit to the owner to get paid your final payment, I no longer have time to send that notice to owner. I don't know if that's really what the direction of your question is. So
I think what I'm seeing it as, I think you just need to make sure that you're getting the releases from your subs saying that, yes, they have been, they're releasing you from that.
Obviously, I agree with Jesse in the sense that if you know that that supplier exists before you pay the sub, you need to get a release through the same period of time for the sub and the supplier. If your question is, well, I'm paying my sub and I don't even know the supplier exists, how do I get a release from them? That's a tough question. What we would recommend is you have a good subcontract that requires that they pay all their bills, so you have a contractual right to pursue them for indemnity or breach of contract. And then we have release forms that we recommend our contractors and subcontractors to use with their subs down the line that requires that they verify that they've in fact or affirm that they've paid their subs and suppliers.
Okay, wonderful. Thank you so much for answering those questions. I think that is all the questions that have come through. If anyone does have another question that wasn't addressed, please feel free to reach out and we'll be sure to answer any questions for you. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access all of these incredible resources. There's so much on there for you guys to learn and discover, so please check it out. Next slide, please. All right, our next webinar with Alex will be June 17th. That will be Your Lien is Worthless on Tenant Buildouts, and Here's Why. That's going to be a great one to join for. And then the other one is going to be July 17th. Stop, don't sign that waiver unless it says this. That's another really informative one. So please sign up for free at sunraynotice.com/education. We'd love to be able to see you there. And then the next, oh, there we go. Okay, and if you are in the Boca area or even Fort Lauderdale or even Miami, if you're willing to travel, we have a seminar, a live seminar in person in Boca. That's going to be how to get paid faster with liens, bonds, and contracts. That's actually next month on March 13th. So if you're available, please get on our website, sign up for that. We'd love to be able to see you guys there. It's a 3-hour seminar where Alex and Ariella will discuss all the ins and outs of what you need to know and tips and tricks in this industry. So please, we'd love to be able to see you there. So go ahead and sign up. And then if you don't mind, give us a review on Google. It takes about a minute, but we really do appreciate any feedback you can provide to us. And then the last slide, if you don't mind. That is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you at our next webinar.